Second Amendment historian and constitutional lawyer and member of the Supreme Court Bar, Stephen Halbrook, has just written a very powerful piece in the Volokh Conspiracy, explaining why, in his view, the U.S. Court of Appeals for the Fourth Circuit in the Snope versus Brown case screwed up so badly it's necessary for the U.S. Supreme Court to grant cert in the Snope case to resolve some of the insanity of the Fourth Circuit upholding the Maryland ban on semi-automatic rifles, including the AR-15. So let's go over some of the powerful technical arguments about ballistics and the history of rifles that Stephen Halbrook goes over in his post when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee for a 2025 Gundy's Award in the category of Top Voices of the 2A, Second Amendment, for Las Vegas at the end of January. If you're going to be voting for the Gundys, a link is in the description of this video as to where you can click on the link and vote. You can vote every day between now and the end of December. Check it out, Top Voices of the 2A in the Gundys. If you're so interested, vote for Mark Smith and the Four Boxes Diner this year. I feel like we can win it. We've been a finalist before, have never won one, but we're going to do it this year. I feel good about it. All right, folks, so here's the story. This week is a very big week for us. I want to give you a heads up on X at Four Boxes Diner, maybe even here as well, with a community note, that on the 17th of December, just a few days away, the United States Supreme Court is going to conference the Snope versus Brown case. This means that all 9 Supreme Court justices will get into a room. Nobody else will be there. And they will vote whether or not to hear the AR-15 ban case out of Maryland, Snope versus Brown, up on cert from the U.S. Court of Appeals for the Fourth Circuit. You need 4 votes. 4 votes out of the 9. 4 votes out of the 9 to grant cert. By granted cert, it means the Supreme Court will actually hear the case on the merits and rule as to whether or not semi-automatic rifles, such as AR-15s, are protected by the Second Amendment. This should be an extremely easy case for the Supreme Court to grant cert on and rule in our favor. It is clearly guided by the Supreme Court's decision in Heller, and there's no doubt at all, because even the ATF admits it, Justice Sotomayor admits it, everyone understands it, that AR-15s and semi-automatic rifles are ubiquitous. They are everywhere. There are tens of millions of these in the United States. They are definitely in common use by Americans for lawful purposes. So if the Supreme Court grants cert, I don't see how we lose this case. Anything is possible, of course. But the reality is the fight of our lives, post-Bruin, is getting the Supreme Court to grant cert in the Snope versus Brown case. This is the end of the trifecta for 2024. Trump's election was number 1 in my view. Control of the United States Senate by Republicans was number 2. So we get our judges confirmed. Supreme Court justices confirmed if available, if needed. And the third part of the trifecta, the third leg of the stool, whatever metaphor you want to use, is the Supreme Court granting cert in Snope versus Brown. This is the ball game, folks. We win this, the anti-gun movement is really in big-time trouble. Big-time trouble. Huge trouble in American life. They already are, but losing AR-15 bans, semi-automatic rifle bans, would be catastrophic to the anti-gun movement and a huge win for freedom across this great country. So with that said, there's a lot being written about the Snope versus Brown case, of whether the Supreme Court should grant it, which in my view they should grant cert and hear the case on the merits and decide it come June of 2025. And I think if they grant cert, we will win. So Stephen Halbrook, a friend of the show, he's been on a few times, Second Amendment historian, author of many books, constitutional attorney, member of the United States Supreme Court Bar, has written a powerful post explaining why he thinks the Supreme Court should hear the case of Snope. He posted this on the Volokh Conspiracy. If you're not following the Volokh Conspiracy, you maybe ought to do so. Take a look at some of the articles they have over there on a lot of constitutional questions. Certainly if you're a law student or a legal scholar and you're not following the Volokh Conspiracy, in particular Stephen Halbrook's posts on the Second Amendment, I urge you to do so. I'll put a link to it in the description of this video. Now, what's very interesting about this post by Stephen Halbrook is he gets very technical. And a lot of you gun guys out there are going to really enjoy this discussion, because he takes to task Judge Harvey Wilkinson's misconstrual and making stuff up about ballistics of ammunition, of bullets, the trajectory, terminal ballistics, and the like, by really pointing out the absurdity of the Fourth Circuit ruling that suggests that 5.56 rounds, 2.23 rounds are so uber deadly compared to most ordinary deer rifle rounds. To start us off as to how this all came about, it's with this absurd statement by Judge Harvey Wilkinson, who wrote the majority opinion against the Second Amendment in the Snope versus Brown case. This is what Judge Wilkinson had to say, and you'll see why it's absurd. We played parts of this for you back when this was argued in March, and this will remind you when I read it to you now. Judge Harvey Wilkinson asked the appellant's counsel, "Have you ever fired an M16? The attorney for the Second Amendment answered, "I have not, Your Honor." Judge Wilkinson asked, "Well, I have." It's more of a statement than a question, right? Judge Wilkinson said, "Well, I have, and we used them back when I was in the Army Reserve. That was way back, way back." By the way, he served in the Army Reserve in 1968 through 1969, as a side note. Judge Wilkinson went on to state, listen to this, folks, for you guys interested in guns, you're not going to like this. You're going to just roll your eyes. Here's what he said. Quote, this is Judge Wilkinson. "And when we took shots at the targets, wherever we hit, there was nothing left. The kick was so powerful that when the bullets hit the human beings, it splintered them into all sorts of little pieces. There was very little left of the human being, and that was a very early model of the M16. And since then, it's been perfected into an even more lethal weapon than the ones that I used." Now, obviously, for anyone that understands ballistics and firearms, even constitutional lawyers such as myself, understand this is simply not accurate. It's not close to being accurate on any level, because we understand the size of an M16 or AR-15 round, 5.56 223, is never going to do anything like this. And the good news is that Stephen Halbrook makes this exact point in the Volokh Conspiracy. This is what he says. The M16, like most AR-15s, fires the relatively underpowered 5.56 millimeter cartridge. It has very little kick, and while obviously the 5.56 can be lethal, in no way does it even come close to splintering a human into little pieces. It won't even do that to a squirrel. Now you may be asking, why is any of this ballistic discussion even important? Well, the answer is it should not be important, because the focus, of course, if you apply the in common use test by Americans for lawful purposes, none of this stuff is relevant. The good and the bad of guns is not relevant. That is exactly what Justice Antonin Scalia said at the end of his decision in Heller, that the balance of the good and the bad of guns has already been done by the Founding Fathers, and it is found with the Second Amendment's text and its history. It's not allowed to be rebalanced away, even if we, meaning the black robe mystics basically is what Justice Scalia is referencing, even if the black robe mystics and the judges, third branch of government, don't like it, it can't go away because it's in the text of the Constitution and must thereby be respected and enforced. But the reason why this is important is because, of course, this is like a form of a logical fallacy of an appeal to emotion, to make it scary, to make it gory, make it bloody, so that people go like, ooh, guns are bad, guns are bad. Well, Stephen Halbrook addresses that point right here and right now. Professor Halbrook writes, quote, "Descriptions of wounds in the most gory manner possible to justify a gun ban loses sight of the fact that the Second Amendment protects arms, which include anything that a man wears for his defense, or takes into his hands, or useth in wrath to cast at, or strike another." This is the Supreme Court's decision, Heller, quoting Timothy Cunningham's 1771 legal dictionary. And Professor Halbrook points out, of course, quote, "that criminals injure and kill innocents with arms is reason for innocents to have arms, not to ban them." That's powerful language, but you can see where the anti-gunners want to go, where the Fourth Circuit wanted to go. They wanted to make it scary, wanted to be gory, wanted to be bloody, try to distract the U.S. Supreme Court and others from considering this case. But that's simply absurd because the way they went about trying to prove it in the Fourth Circuit, even though they're not even allowed to get into this at all, but the way they try to do it is talking about ballistics as if they knew what they were talking about. But we understand that 5.56 and 2.23 rounds are underpowered compared to hunting rifles. And I'm happy to say, and I should say hunting rifle rounds, I'm happy to report that Professor Halbrook makes this exact point in The Bullet Conspiracy today. Here's what he writes. For over a century, millions of American deer hunters have chosen the 30-06 round. That is what our armed forces used in the M1903 bolt-action rifle and the M1 Garand semi-automatic rifle. The 308 or 7.62 cartridge, which the military used in the M14 rifle, perhaps became the most popular deer round of all time, or at least for a time. There are numerous other rounds on the market today of equal or better takedown power, such as, of course, the 6.5 Creedmoor. And then Stephen Halbrook then goes on and talks in detail about the power or lack thereof of these various rounds. He does a little bit of history because, as you know, Stephen Halbrook is indeed the ultimate Second Amendment historian. Here's what he writes next. In 1950, the .222 Remington cartridge was developed for varmint hunting. It evolved into the .223 Remington round, which in turn became the basis of the 5.56 millimeter cartridge adopted by the military for use in the M16 and favored by many target competitors. Neither round is preferred by deer hunters, as most loads are too underpowered to harvest big game. He then goes on and points out that the power of the .223 5.56 round isn't much to speak of compared to typical hunting rounds. It is so underpowered that the armed forces are replacing its 5.56 M16 and M4 rifles with the new 6.8 by 51 millimeter round with the XM7. Again, the reason why I think it's sort of important to talk about these cartridges and these wound capabilities is not that it's actually legally relevant, because they're not. The only legal standard is Heller, which says that if a particular category of firearms is in common use by Americans for lawful purpose, it can't be banned. Now, there may be other ways to get around an arms ban beyond the in common use test, but what we're talking about nowadays, which is AR-15s, semi-automatic rifles, magazines that hold more than 10 rounds, these are clearly in common use. Now, if Captain Kirk invents some sort of phaser in 20 years or something like that, we may have to talk about dangerous and unusual in that context. But for now, none of the issues we're litigating touches fingers with any of that. And we clearly, in the Second Amendment community, win these arguments. It's not a problem. Nevertheless, again, it's important to talk about some of this technical stuff because, as I told you before, a lot of federal judges, in addition to not really understand Second Amendment law, because they don't get a lot of Second Amendment cases, so they don't ever really learn it, they also know very little about basic firearms technology. They don't understand the difference between a barrel and a bore. They don't understand the difference between a revolver and a semi-automatic pistol. They don't understand the difference between lever action, bolt action, and semi-auto. They don't understand any of these basic things. Most of them, I would venture a guess, don't really understand the difference between a shotgun and a rifle and a handgun. Now, it sounds absurd that they don't understand these basic things as an American. But that is the reality because so many of the judges today are drawn from these elite, super urban elite schools with these elite credentials. I know, I was there, I have those credentials, but I'm a little bit unusual in that I actually understand the Second Amendment and firearms technology. But a lot of them, even those that are sympathetic to the Second Amendment, have just no understanding about guns. Largely because they've never been exposed to them. They've never had an opportunity. It's always been very difficult for them. It's very difficult to learn about guns. If you live in New York City, no matter how much money you make, and you make a lot of money in New York City, most people do, a lot of money. And even then, the familiarity with guns is so limited because it's just so hard to learn. And if you don't know that you like it, how are you going to go learn about it? You understand the problem. It's a chicken and egg problem. But with that said, Stephen Halbrook does a great job discussing the ballistics here and why what the Fourth Circuit said is hooey and why the Supreme Court should take the Snope versus Brown case and reverse what the Fourth Circuit did and resolve this once and for all in favor of the AR-15. Halbrook writes, quote, Bianchi tells us that the catastrophic damage of AR-15 rounds leaves multiple organs shattered, bones exploded, and soft tissue absolutely destroyed, which often cannot be repaired by trauma surgeons. That potential, of course, exists for wounds from shots fired from firearms of almost any kind. A cartridge does not care what type of firearm fires it. A .223 round fired from an AR-15 will cause exactly the same wound as one fired from a single-shot rifle that Maryland does not ban. Yet the Bianchi court, which of course is the Snope court, seeks to justify the ban on certain rifles based on the wounding potential of the cartridge they fire when countless other rifles fire exactly the same cartridge. Presumably all rifles that fire this cartridge, not to mention all that fire more powerful cartridges, may be banned. That would be almost all rifles in the United States other than the .22 rimfire. Well, I think Stephen Halbrook did a very good job getting into the nitty-gritty details of some of the ballistics here and really taking apart some of these arguments and assertions made by the U.S. Court of Appeals for the Fourth Circuit out of Maryland and Virginia, and specifically some of the hyperbole from Judge Harvey Wilkinson there, who wrote the majority opinion for the Fourth Circuit. And I'm hopeful that the U.S. Supreme Court will finally take this AR-15 semi-automatic rifle ban case. They will take Snope versus Brown and resolve this issue once and for all. It's a very easy case for them to take and decide if they have the fortitude to do so. We'll see what happens. I can't predict this. This is a close call. I can see it going either way. But we certainly will have an answer on this by the middle of January. So, we will keep you informed as we move forward. Well, anyway, there you have it, folks, for today. Hope you enjoyed today's episode. Make sure you like this video and share it. Subscribe if you haven't done so. We're trying to get to 200,000 subscribers here on the channel. We're also now posting on Rumble, by the way. So even if you don't watch Rumble all the time, please subscribe and follow me on Rumble. We only have maybe 100 people following us over on Rumble because we're brand new. They were only like a day or two over there. So, but we are trying to add Rumble, and hopefully we'll add some other podcasts at some point very soon. And make sure you follow me on X at 4boxesdiner. Don't forget about the Gunnies. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.